So, when I said that there was probably blood in the water based on the funny business that was going on with the withdrawal and the things that were going on with the deposition, I didn't exactly anticipate this. Let's let's get into it. Let's get into it, guys. Holy cannolis. This is a wild development. I usually when it comes to the titles and thumbnails and stuff, I don't want to be too clickbaity on things. So, if something doesn't feel like it's really a bombshell, I don't necessarily want to call it a bombshell. So when I put that in the title the other day, I was like, yeah, like this seems like there's something here. Like there's some information here that is that somebody is really, really guarding. They don't want to give over to the other side. And, like I said, if you watched my video the other day, I you saw me say it, right? Where I said that this is usually because they have information that is really damaging to their case, right? I didn't anticipate that the lawyer might be lying about what's going on with their client. Client, right? Okay. So it looks really shady. It looks really shady. And the reason why there's this new information, by the way, I should have mentioned this, is at so in my last video, I mentioned how there were two motions that were filed. There was one motion filed in the Smithline case, one motion filed in the Bianco case. The motion filed in the Smithline case was the motion to withdraw, saying she breached the attorney-client, she breached the retainer agreement. Interesting. I definitely would love to see the retainer agreement now to see he even cites a couple paragraphs, saying which ones um, she breached and saying that she had become unreasonably difficult. All of that looks like BS now. Based on what we've seen since then. And then anyway, so it's saying that for all of those reasons, he needs to now withdraw. And then in the Bianco case, he filed a motion to modify the subpoena, basically to say, hey, this subpoena was supposed to have her deposition beyond the 17th. She couldn't show up on the 17th. And so now we're requesting a um, 90-day, what's it called? A continuance on all discovery so that, you know, she has time to find new counsel, and if there's any kind of discovery requests, there's some due dates, and we want to make sure that she's not left in a weird precarious position, because I, as an attorney, have certain professional obligations in withdrawing from representing a client, and so I can't leave them in a vulnerable position. So in the Bianco case, the new information that we have now comes from an opposition filed by Marilyn Manson's attorney, Howard King, saying, nope. Nope. This guy is misrepresenting, is the term that they use. Misrepresenting is a very classy way of saying this guy is lying through his teeth. He's a lying liar who lies. And okay. I think before I summarize more, I've spent probably enough time summarizing to sort of explain the whole thing about the situation. But there are receipts. There are receipts here. There are text conversations between Miss Smithline and her attorney, which ostensibly Miss Smithline has given to other people. Now, I will say before we go further, there are certain professional obligations. If if you think text messages between Miss Smithline and her attorney and you think attorney-client privilege, you're on track, right? Because communications between these two individuals are privileged. They are meant to be kept confidential. However, that is a privilege that is owned by the client, meaning the client can waive that. She can send any individual who is represented by an attorney can waive the attorney-client privilege by sharing those communications with other people. And so they are no longer privileged. Then they're free for anybody to look at or to hear or whatever, if it's recorded in some way. So there are certain text messages showing that Mr. Ellwanger is representing to the court and to opposing counsel and to the world that he is withdrawing from representing Ms. Smithline. But it looks like, from this new information, it looks like she fired him in April of 2022, which has all kinds of implications. All kinds of implications. And there are a lot of different communications that he has made to the court, to opposing counsel, and to Ms. Smithline that are questionable at best, in my opinion. Let's get into it. Okay. Here's the opposition filed by Marilyn Manson's attorney. Defendant Brian Warner's opposition to motion to modify the subpoena. Okay, part 1, introduction. Non-party Ashley Morgan Smithline's. Oh, and just a reminder, this is filed in the Bianco case. This is why she's a non-party here. She's a third party. She's not a plaintiff. And yeah, okay. Non-party Ashley Morgan Smithline's untimely motion to modify the deposition subpoena served on her should be denied because the subpoena does not impose an undue burden on her purported and her purported counsel that filed the motion, J.L. Winger, who remains counsel for plaintiff Esme Bianco, has apparently misrepresented Ms. Smithline's wishes and the reasons she could not timely comply with her subpoena. Okay. A number of these things. Purported counsel. Her purported counsel, her claimed counsel, the guy that says he represents her. The guy claims he represents her, but he doesn't. He doesn't really. This is what this implies. It's throwing just a little bit of shade, which is fun. He's apparently misrepresented Miss Smithline's wishes and the reasons she could not timely comply with the subpoena. He's lied to you, Your Honor. He's lying to the court. Ms. Smithline's wishes and the reasons she could not timely comply with the subpoena. Yeah, it's just, yeah. Far from having any merit, the motion is a clear attempt by Mr. Ellwanger to buy himself time in light of the serious ethical questions arising from his withdrawal from representing Ms. Smithline and his continued representation of plaintiff Bianco in this action, in which Ms. Smithline is a key witness. Ms. Smithline's deposition was originally scheduled with mutual agreement of counsel for August 17th, 2022, and the witness appearing by Zoom from England. But in the afternoon on August 16th, Mr. Ellwanger urgently requested that defendants agree to postpone it because he said Ms. Smithline could not attend and was on a plane to Los Angeles to receive emergency psychiatric treatment. Relying on Mr. Ellwanger's representation, defendants agreed to continue the deposition to the mutually agreed date of August 30th, contingent on Mr. Ellwanger's promise and agreement to provide a complete production of the documents requested in the subpoena by the end of the day on August 16th, which documents he said were already in his possession and ready for production, and to later provide a written note from Ms. Smithline's treating professional that she was unable to appear on August 17th. Now, couple notes about this. Someone had asked in the comments yesterday on my last video about the agreement to provide a complete production. You know, this part right here, which he said were already in his possession for reproduction or for production. Sorry. So someone had asked, you know, like, is he really lying about this issue? And I cautioned them because I was like, you know, I don't know. We're getting this information from emails back and forth between the two attorneys. Either side can be sort of blustering a bit, and you know, when we're talking about like one of the attorneys characterizing what the other person said in an email that goes back and forth, you want to be careful about taking that at face value because of the fact that this is an adversarial process. The attorneys, there can always be a possibility that that the attorney could be saying that and describing, what the other person said or did in a way that's most favorable to them, that isn't fully accurate, or that the other side at the very least wouldn't agree with. But here, this is Howard King making a representation to the court. This is Howard King making an argument on Manson's behalf to the court, which is different. It's different than just an email to the other side saying, "Hey, you said such and such and such and such." Because there's no, I mean, not to say that there's no requirement for them to be truthful, but like, you can. I would say that you have a little bit more room to bluster and stretch things, because that the other side is going to come right back and like, say that's not true or whatever, like you expect kind of the same of the other side. But here they're saying, pretty much unequivocally saying, that he said he had the documents already in his possession. Because yesterday I was like, yeah, I don't know. I'm in like nuanced territory here, right? Like I'm trying to read through these things and be like, I don't know if we can really go down the road of like concretely saying like, yeah, he said that the documents were in his possession, because that was just a characterization by Howard King of something that Ellwinger had told him, without seeing like what I basically said was like, I want to see the actual communication from Ellwinger to see if, if that actually is true, or if there was just some, like if he maybe said something that sort of hinted at it and seemed like, oh, I don't, like the other side just took that as, oh, you have it. I'm assuming you have it, or something like that. But this is like I said, this is a representation to the court saying, no, he said he had possession of these documents. Mr. Ellwinger immediately broke his promises by producing only 4 redacted text messages on August 16th, which no person could reasonably believe was a complete production, because these documents explicitly refer to other responsive communications that were not produced. Defendants informed Mr. Ellwinger of this, but he has made no effort to supplement the production. So basically saying, and this is part of discovery. I've dealt with this before, where you make a request for documents of the other side, and they say, yes, we'll produce, and then they send over like a few documents, and you're like, there were 30 requests here, and each of those requests like kind of refers to like a series of documents. There's a lot more that should be here. Like this is not responsive to everything that we requested, and you didn't object to XYZ. So it's like when that happens, yeah, I'm pissed if I'm on the receiving end of those documents, right? Because I'm like, here I am expecting a full production. The other side doesn't say like, hey, we're having trouble. Like, hey, I need a little more time to gather all of the documents that you need and that you're entitled to. Like, that's normal. That's normal, and that's something that would be expected, sometimes expected, but like reasonable and allowable. I can respect that when I'm the counsel that's requesting those documents, and the other side is just having a hard time, either because they're trying to coordinate with their client, or they're trying to go through and make sure that there's no confidential information that needs to be properly redacted. So yeah, if you make a documentary request and the other side doesn't give everything that's responsive to all of your requests, you are entitled to fight about that. So okay, anyway, let's keep going on. Mr. Ellwinger also never produced a medical note to substantiate his representations that Ms. Smithline was unable to attend her deposition on August 17th. Instead, he has since filed a motion to withdraw as Ms. Smithline's counsel in her separate case against defendants. And the day before Ms. Smithline's rescheduled deposition in this case, he filed the present motion to modify the deposition subpoena to provide Ms. Smithline 90 days to secure a representation by new counsel. But what's worse, after Mr. Ellwinger filed these motions, Miss Smithline unilaterally emailed defendant's counsel communications between her and Mr. Ellwanger, which she has also distributed to third parties online, showing not only that she was never coming to Los Angeles for emergency medical treatment or undergoing treatment elsewhere, but also that she fired Mr. Ellwanger months earlier in 2002. That's bad. Bad for Ellwanger. Really bad for Ellwanger. Like, if this is true, he lied to everyone. He lied to the court. That's a that's a no-no. That's I mean, to say that that's a no-no is like so small. Like, like that is your professional reputation that you are just throwing into the wind and just being like, whatever, court. I oh my God. Like, I can't, it blows my mind. Whenever I am looking at these attorneys in these cases, and especially one who I'm embarrassed to say went to my law school. Mr. Ellwinger apparently also went to University of Texas long before I went. So I because when I looked him up, I was like, oh, cool, hook 'em. Now not so cool. But but anyway, I can't remember where I was going with that. I got distracted by my own thoughts, but like, oh, it's just bad. Oh, so I never want to like assume that these attorneys are unethical or incompetent or anything like I always want to assume that they are doing the best that they can and that they are just being ethical attorneys, whether it's because they're good people or more likely because of the fact that there are certain rules in place for licensure which have some very harsh penalties oftentimes, whether it's monetary sanctions or sometimes going so far as losing your license. um Misrepresenting to the court that you are representing a client that you are actually not representing is one of those things that can really land someone in some hot water. Like that's a really big one. That's a really big one. Attorneys will make mistakes just like anybody else, right? It is sometimes your zealousness will get the best of you, for example, or something, I don't know, or you slip up in some way, miss a deadline, things like that that like keep an attorney up at night or like make you like suddenly gasp in the shower because you're like, "Oh my God, did I miss something?" Those are the kinds of things that you can still get into trouble for. But like that's why this is just, it boggles the mind. Okay, let's continue. Let's continue reading. Okay. Miss Smithline added that for a Me Too lawyer, Mr. Ellwinger doesn't listen to the word no. Oh, God, that's so bad for him. In response, defendant's counsel informed Miss Smithline, copying Mr. Ellwinger, that as long as J. Ellwinger is your counsel of record, I am not permitted to communicate with you absent his consent. Miss Smithline responded, stating unequivocally, with Mr. Ellwinger still copied, that she had fired Mr. Ellwinger and he is lying. And he is lying. So I did see one thing about this is that I did see on Twitter some people being like, well, maybe he just didn't take her seriously. This is a serious matter for attorneys when it comes to the professional rules of conduct in any state. So when you are licensed as an attorney, maybe I'll back up a little bit. When you're licensed as an attorney, in every state in which you are licensed, you are bound by the rules of professional conduct in that state. So the CRPC, the California Rules of Professional Conduct, bind the things that I do and the ways that I work as an attorney if I'm representing clients or doing other stuff. So, and the same thing, I'm licensed in California and DC. I'm also bound by the DC rules. Mr. Ellwinger is licensed in Texas and California. So he's bound by both sets of rules here. And the thing about those rules is that, like I said, they have very harsh penalties. So if there's any sort of ambiguity, if the attorney gets a communication from a client and the client says, I no longer want you to represent me, if there's any ambiguity to that, the lawyer can't just like walk around and be like, oh, you don't mean it. You don't actually mean it. I'm still going to represent you. Like, I know that you're lying. I know that you're just kidding. Um, you can't, the lawyer can't just like take their own interpretation of that and like continue on with business as usual. If there's any ambiguity, it's up to the attorney to get clarity from the client to say like, do you actually mean that? Because like, and you can explain to them like, okay, if that's what you want, this is what's going to happen. I have to do XYZ. I need to make sure that this is the case. And most attorneys, the ones who are thinking properly or maybe thinking at all, are uh they're going to get that in writing because it's better for the attorney to have that clarity. Um yeah. Yeah. I mean it's so so as an example, if I'm fired by a client um over the phone and they say like, "Hey, uh this is my name is such and such. You've been representing me and I'm not happy with your representation. So I'm gonna go elsewhere. I don't want you to represent me anymore." Um, you send an email afterwards between you and the client. You have certain email correspondences. You've got emails going back and forth between the two clients, and you're generally speaking going to confirm that in writing to say, hey, okay, so we just had this conversation over the phone. You said you didn't want me to represent you anymore. I explained to you XYZ, and this is the result. So I will be filing a motion to withdraw as soon as possible. In the meantime, you have such and such deadlines. I recommend that you find new counsel so that you can have those covered. I'll do whatever I need to make sure that your things are. There are certain steps that ethically would be required of the attorney. If we're talking about active litigation, they have to get permission from the court. Generally speaking, it depends on the jurisdiction, but almost every jurisdiction that I know of would require the attorney to get permission from the court to withdraw. If it's like long before trial, like at this stage of litigation, um the court generally speaking is probably going to allow that attorney to withdraw, regardless of whether or not there's another attorney waiting on the wings to represent this person, because people do represent themselves. It's not generally advised because there are so many pitfalls that can happen. There's a lot of process. I mean, even you can just get stuck in the weeds of like the process of how to litigate a case. And so somebody who hasn't been trained on the laws, it's incredibly difficult for anyone to represent themselves, and just also the psychological, emotional aspect of it too. Anyway, but like, so people do represent themselves. There doesn't have to be some other attorney waiting to represent this client for after this attorney leaves. Um but anyway, okay. So anyway, all of that is to say that if there's any ambiguity, a lawyer can't rely on that and say, "Oh, this they were just kidding. They were just kidding." I can just ignore what they said when they said that they didn't want me to represent them anymore. um, okay. Let's continue. Thus, contrary to Mr. Ellwinger's arguments in the motion that Ms. Smithline will be prejudiced absent a 90-day continuance to find new counsel, Ms. Smithline is conducting herself as if she wishes to proceed on her own, which is not uncommon with third-party subpoenas. There is no evidence she wishes to retain new counsel or postpone the deposition, nor is there evidence to justify Mr. Ellwinger's delay in waiting until August 29th, the day before the rescheduled deposition, to file the motion based solely on his quote unquote withdrawal, quote unquote withdrawal, because they're this is more shade right here. These quotations right here saying he's calling it a withdrawal, but is it really? Because he's been fired long ago. Withdrawal given Miss Smithline's repeated statements that she fired him months earlier. Even taking Mr. Ellwinger's word that Miss Smithline assented to his termination on August 19th, the motion is still untimely. He cannot justify waiting more than a week after Miss Smithline reconfirmed his termination as her counsel, blithely ignoring the extensive preparation defendant's counsel had to undertake and the many requests for Mr. Ellwinger to confirm whether Miss Smithline was appearing for the rescheduled deposition. The motion should be denied and Miss Smithline's deposition should be ordered to proceed forthwith. Part 2, factual background. Subpart A, multiple women falsely accused Mr. Warner of abuse in early 2021. Now, remember, this is an opposition that's filed by Marilyn Manson's side. So the facts that are alleged here are going to be they're going to be framed in a way that is most beneficial to Marilyn Manson. So let's see what they say in this particular case. Mr. Ellwinger represents Miss Bianco in this action and purports to have represented Miss Smithline in the action filed against defendants captioned Smithline v. Warner et al. Mr. Ellwinger was referred to Miss Smithline by Miss Bianco. That's interesting. That is interesting because if there's some unethical stuff going on here, it brings up a lot of questions about his role. Anyway, interesting. Miss Smithline claims the abuse took place in 2010 and Miss Bianco in 2011. Miss Bianco, Miss Smithline, and other women who simultaneously emerged with false allegations of abuse in early 2021 have stated in court filings that before making their public accusations against Mr. Warner, all based on acts alleged to have occurred as much as 10 or more years earlier, they met and spoke with each other, often as a group, regarding the accusations they would make. See, for example, document 18 at 12, plaintiff did not recognize the true extent of her psychological injuries, nor that the actions committed by defendant constituted sexual assault and sexual battery until meeting with other victims and speaking about her abuse in 2020. And then also citing to Smithline v. Warner et al., the true extent of the injuries suffered by Ms. Smithline were not fully realized until fall 2020 when she began meeting with other survivors of Mr. Warner's abuse. And the reason why this was probably alleged in these other cases is because of the fact that these incidents were 10 or more years ago. And so there's an issue of statute of limitations. And I understand that Ashley Walters' case against Marilyn Manson was dismissed on that ground, on the grounds of statute of limitations. I also understand that I think she's appealed it, but so I don't know where exactly that is or where that is in the process specifically, but yeah, interesting that they've been able to sort of argue, sort of extend that reach of the statute of limitations a little bit based on the damages or based on their perception of what had happened. Part B. Mr. Warner subpoenas Ms. Smithline in this action. On July 1st, 2022, Mr. Ellwinger agreed to accept service of a subpoena on behalf of Ms. Smithline in this action. Mr. Warner's counsel asked Mr. Ellwinger to confirm he still represented Ms. Smithline, given that in May, Ms. Smithline left voicemail messages for Mr. Warner's counsel stating she fired Mr. Ellwinger, who she referred to as her former attorney. Whoa! In May. Okay. Interesting. Mr. Ellwinger responded that he still represented Miss Smithline. That's a straight up lie, it sounds like. On July 12th, Mr. Ellwinger stated that Miss Smithline would be available for a video deposition on August 17th. Accordingly, Mr. Warner served the subpoena for an August 17th deposition. The subpoena included a single document request, all written communications with Esme Bianco, Evan Rachel Wood, and or Ashley Gore, aka Elma Gore, regarding Brian Warner, including but not limited to text messages, email, social media messages, and any other direct messages. Ms. Smithline did not provide any objections to the subpoena. No objections. Ooh, okay. No objections at all. On August 10th, counsel for Mr. Warner emailed Mr. Ellwanger asking whether all responsive documents would be produced at least 48 hours before the deposition, which is common. Mr. Ellwanger never responded. Part C, Ms. Smithline postpones on less than 24 hours notice. On the afternoon of August 16th, Mr. Ellwanger called counsel for Mr. Warner and stated that Ms. Smithline would not be able to appear at her deposition the next morning due to medical reasons, quote unquote, which Mr. Ellwanger explained meant she was flying to Los Angeles to receive treatment for, quote unquote, emergency psychiatric issues. In exchange for Mr. Warner's agreement not to require an emergency motion for protection, Mr. Ellwanger agreed to reschedule the deposition to August 30th and promised to provide, one, Ms. Smithline's complete production of documents by August 16th, and two, by August 30th, a written report of her treating professional confirming that Ms. Smithline was medically unable to appear tomorrow and setting forth any further purported restrictions, including the basis, therefore, that might affect her ability to sit for deposition on August 30th. Part D. Ms. Smithline fails to comply with the subpoena's document request. On the afternoon of August 16th, Mr. Ellwanger's office produced documents purportedly on behalf of Ms. Smithline. However, the production was facially deficient. On its face, it was deficient. We could tell just by looking at it that this was not everything that we were requesting. This couldn't possibly be. And we could tell right away. That's what that means. The mere 76 pages of documents comprised only 4 text message chains involving Miss Smithline and Miss Bianco, 2 of which were Miss Bianco's, not Miss Smithline's documents. Indeed, the documents bore Miss Bianco's bait stamps. There were no emails and no communications whatsoever between Miss Smithline and Miss Gore or Miss Wood, and the documents themselves internally referred to other communications Miss Smithline did not produce. Further, over a dozen pages contained redactions, and on August 17th, Mr. Ellwanger's office provided a privilege log for only some of the redactions, which purported to claim attorney-client privilege over communications between Miss Bianco and Miss Smithline without any attorney. On August 17th and 18th, Mr. Warner's counsel asked whether Mr. Ellwanger served the complete production he had promised. Mr. Warner's counsel also asked whether Miss Smithline was in fact in Los Angeles, as it appeared from her Instagram account that she was still in London. Yeah, that would make me ask the same thing. Mr. Ellwanger responded, stating the 4 chats and privilege log were responsive to the subpoena. Basically saying this is all the information that there is. The other thing about this, by the way, is that the kinds of communications that he did provide were between Miss Smithline and Miss Bianco. What that tells me is he probably happened to have those because he got those from Miss Bianco, because he still represented Miss Bianco, right? So he probably had those for purposes of discovery with her. So there's a reason why he didn't have any communications between Miss Smithline and anyone else, because he couldn't get those because he didn't represent her anymore. Oh my God. This is just wild, you guys. This is crazy. However, he could not confirm that these were the promised complete production. Oh, okay. So he couldn't promise that they were everything. Never mind. So I take that back from earlier. Mr. Ellwanger also stated in response to the question about Miss Smithline's whereabouts, I already told you she's in Los Angeles. On August 24th, counsel for Mr. Warner emailed Mr. Ellwanger explaining the numerous deficiencies in Miss Smithline's document production, including the missing documents and baseless claims of privilege. He asked Mr. Ellwanger to confirm Ms. Smithline would, 1, supplement the production no later than Friday, August 26th, including to provide unredacted documents, and 2, appear at her rescheduled deposition on August 30th. Mr. Ellwanger never responded to this email. Not good. Not good for Mr. Ellwanger. Part E. Mr. Ellwanger fails to substantiate the supposed August 17th emergency and refuses to confirm whether Ms. Smithline will attend the rescheduled deposition. On August 25th, Mr. Ellwanger emailed counsel for Mr. Warner stating that, for reasons which I am ethically required to keep confidential, I cannot provide the written assessment. from Ms. Smithline's treating psychiatrist, which Mr. Ellwinger previously promised. Mr. Ellwinger further stated he was going to have to file a motion to withdraw as counsel for Ms. Smithline. However, he would not answer whether Ms. Smithline still intended to sit for her rescheduled deposition or whether she would supplement her deficient document production. Mr. Ellwinger seeks to withdraw after significant delay, confirms Ms. Smithline will not appear at the rescheduled deposition, and seeks relief from the court on less than 24 hours' notice. On Saturday, August 27th, Mr. Ellwinger filed a motion in Smithline v. Warner et al., seeking to withdraw as counsel for Ms. Smithline. Mr. Ellwinger claimed Ms. Smithline's conduct has rendered it unreasonably difficult for counsel to carry out the representation effectively, and she breached paragraphs 9 and 16 of the retainer agreement. I'm wondering if his like when he says that her conduct has rendered it unreasonably difficult for him to carry out the representation, that maybe what he means by conduct is she fired me. Because firing him would also make it unreasonably difficult for him to carry out representation of her effectively, right? Like that's not what that's supposed to mean, but like maybe he's like, yeah, like we'll call it that. She breached paragraphs 9 and 16 of the retainer agreement. Man, I said this earlier in this live stream, but I would love to see the retainer agreement. It's we're probably not going to see it because it's generally kept confidential. Unless Miss Smithline decided to like really burn the ships and just like post it on Instagram or something. It's always possible. He did not attach the agreement or explain what this meant. Mr. Ellwinger further stated Ms. Smithline knowingly and freely assented to termination of the representation on or about August 19th, 8 days earlier. On August 29th, Mr. Ellwinger asked to take the August 30th deposition off calendar on the grounds that he sought to withdraw as counsel. When Mr. Warner's counsel would not agree, Mr. Ellwinger stated incorrectly he intended to file a motion for protection, which operates to stay compliance with the subpoena, so Ms. Smithline will not be appearing tomorrow. Here we go. Instead of filing an ex parte application that could be promptly adjudicated, Mr. Ellwinger filed a regularly noticed motion on August 29th, seeking to continue the rescheduled August 30th deposition. In it, Mr. Ellwinger argued it would be an undue burden for Ms. Smithline to appear on August 30th pro se or with Mr. Ellwinger as her counsel. He provided a declaration nearly identical to the one attached to his withdrawal motion. Okay, part G. Ms. Smithline fails to appear on August 30th and tells Mr. Warner's counsel she fired Mr. Ellwinger months ago. Crazy. Between the afternoon of August 29th and the morning of August 30th, after Mr. Ellwinger filed his motions, Ms. Smithline sent a number of communications that cast serious doubts on Mr. Ellwinger's timeline of events and his multiple representations to counsel for Mr. Warner that Ms. Smithline could not attend her August 17th deposition because she was in Los Angeles receiving medical treatment. Oh, boy. Ms. Smithline sent a number of Instagram messages to a third party stating she fired Mr. Ellwinger in April 2022. In these communications, she shared screenshots of text message exchanges between her and Mr. Ellwinger from April 2022, in which she stated, "I am looking to discharge you. Please let me know when it's done and what needs to happen." That sounds pretty dang clear. That doesn't sound ambiguous at all to me. That sounds like somebody is saying, "I'm done with you. I'm done with you. Goodbye. What do I need to do to get rid of you?" Ms. Smithline also called Mr. Warner's counsel's office, stating as soon as he picked up that she fired Mr. Ellwinger in April 2022. And Mr. Ellwinger had not been truthful about why she was not produced for deposition. It's citing it at Exhibit 1. Mr. Warner's counsel emailed Mr. Ellwinger informing him of the unsolicited phone call and asked whether Mr. Ellwinger would consent to him speaking directly to Ms. Smithline, which he would not. That sounds about right for the vibe. Ms. Smithline also emailed counsel for Mr. Warner and shared with a third party on Instagram copies of text message conversations between herself and Mr. Ellwinger. Ms. Smithline expressed shock that Mr. Ellwinger told Mr. Warner's counsel she could not attend the August 17th deposition due to a medical emergency. Ms. Smithline, a model, responded, "What? I had to shoot for our hotel. He's a lying liar." Lying liar who lies. Oh my God. In the screenshots of messages she shared, Miss Smithline told Mr. Ellwinger on August 22nd, a week earlier and 5 days after the original deposition, that she could not get a letter from her psychiatrist validating Mr. Ellwinger's excuse because I've been in London since March, not under the care of a therapist. And to stop lying, stop. I wasn't in LA for an emergency health session. Stop lying. Oh, this is really bad for Ellwinger. And presumably regarding the attached messages showing her request to discharge Mr. Ellwinger months earlier, she stated, for a Me Too lawyer, man doesn't listen to the word no in it. Mr. Warner's counsel copied Mr. Ellwinger on his response to Mr. Smithline, which stated, I know you told me that you were no longer represented by counsel, but as long as Jay Ellwinger is your counsel of record, I am not permitted to communicate with you absent his consent, which is correct. That's about all that they can respond. Despite multiple cautionary warnings by Mr. Warner's counsel that he could not speak to Miss Smithline as long as Mr. Ellwinger was her counsel of record, she continued to send emails. Copying Mr. Ellwinger, Miss Smithline stated, short of me saying you're sacked and I fire you, what can I do? She also stated again, copying Mr. Ellwinger, do you see how he's lying? I would trust a fruit bat more than him. And this sucks. This sucks because you have a client who is basically in purgatory, essentially. Like that's what's going on here. She's stuck. She's already told him, yo, you're fired, you're gone, you're done. I don't want you to be representing me anymore. You are not to be speaking for me anymore. And then he says, yeah. Shh. And then he goes over there and continues representing her. And he communicates to opposing counsel as if he's representing her. He communicates to the court as if he's representing her. But I can feel that frustration because she doesn't understand the process. Most people don't. If you're not a lawyer, if you're not a litigator, it really sucks. I feel like she's been taken advantage by this attorney here.